It is now time for us to join the legal landscape. And on the legal landscape today, are you nervous about getting a mortgage? Well, you're not alone. Real estate purchases are the most expensive transactions most people are involved with. And, of course, it is important to know the legal requirements involved with getting a mortgage. Now, although the many parts of the mortgage process are the same across all lenders, there are some key factors that you must consider when taking a mortgage. So today, we are joined by Mrs. Trudy-Ann Dixon Frith, a partner at DunnCox Attorneys-at-Law, to discuss what we ought to know about mortgages. Good afternoon, Mrs. Trudy-Ann Dixon Frith. Welcome to The Edge.
Good afternoon. Thank you for having me.
Thank you so very much for joining us. First of all, Trudy-Ann, can you tell us what is a mortgage?
Okay, very simply, a mortgage is an interest in land that is granted by the owner of land to secure a debt, meaning money, a loan, which he owes to another person. So in exchange for the monies lent, the owner of a property grants a mortgage over the land as a surety or guarantee that the debt will be paid.
All right. And for anyone listening who's saying, but it's such a basic question, Deon, there's always someone who needs to go back to the beginning and will learn it again. Yes. So can you define for us in what circumstances mortgages are usually used?
So within the Jamaican context, mortgages are usually used in loan transactions involving financial institutions such as a bank, credit union, building society. Of course, there can also be personal mortgages and mortgages regarding chattels. But within our context, it's mostly with financial institutions. And the financial institutions usually require that a mortgage be signed in its favor by the owner of the land. A number of other things is that the mortgage is usually registered on the certificate of title to show the whole world that the financial institution, such as a bank, has an interest in the property. And the mortgage is limited to the amount owing under the debt. And lastly, I wish to point out at this juncture that the owner of the land is required to sign what is called an instrument of mortgage. Now, this is a complex legal document. It usually goes on for many pages, and I suggest that it really ought not to be entered lightly, and that any landowner must get legal advice before signing this document to ensure that he fully understands what he's agreeing to.
All right, so you're listening to the professional here. Our guest today is Mrs. Trudy-Ann Dixon Frith, a partner at DunnCox Attorneys-at-Law. And remember, if you have any questions on this topic, mortgages, then you can send them to our WhatsApp line, 876-383-1166, or take a moment as well and call us in studio. 876-906-9559 is a studio line. So, Trudy-Ann, while we have you here with us, tell us the common clauses, some common clauses in an instrument of mortgage.
No problem. Of course, the affected land is properly identified in the instrument of mortgage. The loan amount is usually stated. Importantly, the interest which accrues on the loan and the applicable rates of interest in the Jamaican context, usually a compound interest, which is very important for a landowner to know that it's not simple interest. And thirdly, the amount of monthly payments which is payable towards the debt, that is usually made in equal installments over a period of time. And the usual clause provides that if the monies are paid late, then what are the applicable late fees? Additionally, something that often landowners don't pay attention to is that these applicable late fees themselves attract interest, and it's compound interest as well. And that is a clause that is provided for under the instruments of mortgage. Then there's also what is called the events of default, including the non-payment of the debt. Another usual clause is that once the loan is in default for a period of time, say 2 or 3 months, that the entire loan is payable on demand by the financial institution. That is also something that landowners don't usually pay attention to, and don't appreciate that when even if your loan is in default for a short period of time, the financial institution can say they wish all of the loan to be paid immediately. And lastly, a usual clause is that any monies incurred by the financial institution in protecting the security over the property is fully recoverable from the landowner.
Getting the details here with the legal landscape. I have a question here for you, Trudy-Ann. Apart from non-payment of the loan, what are the other acts which are treated as default under the loan?
So these can include things that are specifically identified under the instrument of mortgage again, and that is why a landowner has to pay really keen attention to these clauses, because, for example, another one that could cause the loan to be in default is leasing the property to a third person without the permission of the financial institution, non-payment of applicable rates and taxes for the property, not maintaining the property, and not insuring the property. So one can say, yes, but I have, for example, paid my loan up to date, but if you don't maintain the property and it's making the property go to waste, as we would call it, then that is also an event in default, and the financial institution can call upon you to pay the entire amount of the loan.
Very important information for us to look at this time. So for our listeners listening, if there's anyone in default, what are the remedies available to the financial institution when their loan is in default?
So the financial institution can take several steps to recover the debt. However, I consider most powerful in its arsenal is that it has what is called a power of sale, and that is a power of sale of the property. So by this, the financial institution can sell the property to a third person to realize the debt, and then the debt would be recovered from the proceeds of sale. Now, here is where it becomes, a lot of times, this is the aspect of mortgages that becomes quite litigious, and persons go to court in seeking to try to prevent the financial institution from exercising its power of sale. But they must do so with caution, because the financial institution, by exercising the power of sale, is specially protected in law. So, for example, the property can be sold entirely for its own benefit. The financial institution doesn't have to wait until it is beneficial to the landowner, for example, for the property to be sold. They can decide whether or not they're exercising the power of sale at all, having regard to their own interest and not that of the property owner. And when exercising the power of sale, most importantly, the relevant documents, the law provides for the relevant documents on behalf of the landowner to transfer the land to a third party, that document can be signed by the financial institution.
All right. That's a financial institution. But let's look at the owner of the property and the rights of the owner of the property when the power of sale is exercised.
So when the power of sale is exercised, the landowner is entitled to what in law we call the equity of redemption in the property. So that if the property is sold, exceeds the debt owing, then the landowner is entitled to the remainder of the proceeds of sale. So a financial institution has to hand over that sum at the end of the sale process. If the property sold, however, does not cover the debt owing, then the landowner still owes the remainder of the debt. In either case, the ownership of the property passes to a third party, and the landowner no longer owns the property.
So what can the owners of the property do when the loans are in default to avert certain actions being taken?
So pay off the debt completely, or pay off the amounts owing under the debt to date. And if you're exercising option 2, you would really need to negotiate with the financial institution in an effort to get some forbearance on the debt to see if they would accept the amount owing to date rather than calling on the entire loan being paid. The options, you can regard them as limited. Quite limited.
All right then. Before we go,
yes.
Can you give us any hashtag Did You Know moments for our listeners?
So yes. So did you know that mortgage properties can be sold without notification to the landowner? In other words, it can be sold without the landowner knowing that it is being sold, that the property is being sold.
Right.
And this can be done if the instrument of mortgage has a clause which waives the service of what we call the statutory notice of sale to the landowners, and most of them do. And then in that event, the land can be sold without the landowner being notified.
Well, you heard it right here on The Edge. The legal landscape. We're inside, was it season 3 already? We want to thank you so much, Trudy-Ann Dixon Frith, who is a partner at DunnCox Attorneys-at-Law, bringing us up to date with everything we ought to know about mortgages. Thank you, Trudy-Ann.
Thank you so much. It was a pleasure being here.
A pleasure having you too. Thank you. All right, join us next week right here on The Edge 105.1, 105.3 FM at 5:33 on a Wednesday. We give you the legal landscape.
You're listening to The Edge 105.1 and 105.3 FM. Your life, your music.
The Edge!